for this public meeting. I'm here. Mark Corrigan.
Here.
Melanie DePalma.
Here.
Roger Nick.
Here.
Michael Schwartz.
Here.
Shelley Sims.
Here.
All those present and accounted for. Okay. The first one we're going to do is a medical marijuana act determination request, and Shelley
This is for
Sims.
the approval of the minutes.
Oh, that's right. All those in favor of the minutes say aye.
Aye.
Disapprove? Nay. The ayes have it.
I'll make the motion. No, quote down.
And I'll second.
You know, I think you were a little better when you were here. You kind of behaved yourself there. Okay, we're going to first do the medical marijuana act determination request. Shelley Sims?
Yes, thank you, Mr. Chairman. The facts pertaining to this request are that the requester is Frederick N. Frank, Esquire. Attorney Frank requests a determination under the Medical Marijuana Act on behalf of his client, who is an unidentified elected county official, and whom I will refer to hereafter as the county official. The question presented is whether the county official would be subject to section 2101.1A and B of the Medical Marijuana Act, where the county official is not involved in any enforcement, regulation, or policy implementation for medical marijuana organizations, and where the county official is not an official of a county that directly receives a distribution of revenue from the Medical Marijuana Program Fund established in section 902 of the Medical Marijuana Act. Mr. Chair, I would suggest that this would be an appropriate time for any interested parties to speak on this matter, if any are present.
Anyone have any questions? Okay, Shelley.
Seeing none. I have reviewed the facts and the relevant statutory provisions, Mr. Chair. The restrictions of section 2101.1A and B of the Medical Marijuana Act involve financial and employment interest. These restrictions apply to current and former executive level public employees, public officials, and party officers, as well as their immediate family members. Of these categories, the only category that the commission needs to consider in this instance is the category of a public official, as that term is used in the act. The Medical Marijuana Act defines the term public official as including individuals who fall within any of 5 numbered paragraphs contained within the definition. Based upon the submitted facts, paragraphs 1 through 4 of the definition would not apply to the county official. In considering paragraph 5 of the definition, it is my view that the county official would not be subject to section 2101.1A and B of the Medical Marijuana Act, subject to certain conditions. Based upon my analysis and comments, Mr. Chairman, I would like to make the following motion. I move that the holding of this commission in this matter be as follows. Based upon the submitted facts, it is the determination of this commission that the elected county official on whose behalf Attorney Frank has requested a determination would not be subject to section 2101.1A and B of the Medical Marijuana Act, subject to the conditions that the said county official is not involved in the development of regulation or policy relating to a medical marijuana organization, and that the county official is not involved in other matters under the Medical Marijuana Act. That concludes my motion, Mr. Chair.
Thank you. Shelley Sims makes a motion, a second by Melanie DePalma. Any questions? All those in favor of the motion in this matter signify by saying aye.
Aye.
Nay. The ayes have it. Number 3, Mr. Schwartz, the civil pending orders consents.
Yes, thank you, Mr. Chairman. We have one civil penalty consent. The case involves respondent Barry Kindt, a member of the Pennsylvania State Apprenticeship and Training Council. Mr. Kindt failed to timely file statements of financial interest for 5 different years: 2014, 2015, 2016, 2017, and 2018. parties have submitted a consent agreement proposing that the commission find that the respondent failed to timely file those 5 years of statements and impose civil penalties in the total amount of $625. The respondent has now filed his delinquent statements of financial interest. Based upon my review of the facts, I am of the opinion that this consent agreement is consistent with commission precedent and is a proper disposition for this case. Therefore, it's my opinion that the commission should impose the civil penalties agreed to by the parties per the consent agreement and order respondent to make payment of the civil penalties to the extent that he has not already done so. If I can make a motion, Mr. Chairman?
Please do.
I move that the commission approve the consent agreement submitted by the respondent and the investigative division imposing civil penalties in the amount of $625 against respondent Barry Kindt for failing to timely file statements of financial interest for the 5 calendar years from 2014 to 2018. I move to the extent that he has not already done so, the respondent shall be ordered to pay the recommended civil penalties agreed to by the parties per the consent agreement within 30 days of the issuance of the commission's order.
Motion made by Mr. Schwartz, second by Shelley Sims. Any questions? All those in favor signify by saying aye.
Aye.
The ayes have it. The next matter is a civil penalty orders defaults. Roger, which,
No, that's,
could we do all these at one shot?
We can, Mr. Chairman, and the only caveat is there's one explanation for the 12th one, given an additional development that I think can be incorporated into a global discussion of these.
Okay.
So these are 12 civil penalty default cases that are now before the commission. The following 12 respondents, who I will identify in my motion together with their positions, failed to file one or more statements of financial interest. In the first 11 cases, the respondents did not take any action or respond to the civil penalty proceedings. In the 12th case, which involves respondent Bomani Housey, the respondent filed his delinquent forms with the commission, but well after the grace period had expired and the civil penalty provisions or proceedings had already been initiated against him. Respondent Housey did not file a timely answer in the civil penalty proceedings, and then although respondent Housey submitted an email asserting various circumstances and requesting that the commission not levy civil penalties against him, the investigative division has provided additional information that shows that respondent Housey had a prior history of failing to timely file statements of financial interest. So following the review of all 12 of these matters, it is my opinion that as to each of the respondents, the commission should levy the maximum civil penalty of $250 for each delinquent statement of financial interest. It is also my opinion that the commission should order for the first 11 respondents that they must file their statements of financial interest. There is nothing of record that would constitute a defense or an excuse for their non-compliance. Based on this analysis, may I make the following motion?
Please do.
I move that the commission levy maximum civil penalties against the 12 respondents as follows. For the first case, I move that the commission levy a maximum civil penalty in the amount of $250 against respondent Geiger, who was an income maintenance caseworker at the Pennsylvania Department of Human Services and who failed to file a statement of financial interest for calendar year 2017. For the following 10 cases, I move the commission levy a maximum civil penalty in the amount of $250 against each respondent for failing to file statements of financial interest for the calendar year 2018. The first is Elaine Hoppes-Goroshko, a dentist with the Department of Human Services. Joseph Smith, a technical assistant with the Pennsylvania Department of Transportation. Gregory Reed, a constable or a deputy constable. Roxanne Rinier, a fiscal management specialist with the Pennsylvania Department of Transportation. William Jackson, a constable or deputy constable. Kelly Willis, an income maintenance caseworker with the Pennsylvania Department of Human Services. Jennifer Kersey, an income maintenance caseworker with the Pennsylvania Department of Human Services. Jillian Baines, who is an income maintenance caseworker with the Department of Human Services. Amani Jefferson, an income maintenance caseworker with the Department of Human Services. And Kathleen Staten, an income maintenance caseworker with the Department of Human Services. For the 12th and final case, I move that the commission levy 5 maximum civil penalties in the amount of $1,250 against respondent Amani Housey for failing to file statements of financial interest for the calendar years from 2014 through 2018. Further, for all of these respondents, with the exception of respondent Housey, they shall be ordered to file their statements of financial interest for the years stated within 30 days of the issuance of the commission's orders.
Motion made by Mr. Schwartz, second. Melanie Capoma. Any questions? All those in favor signify by saying aye.
Aye.
Nay, the ayes have it. Thank you very much, Mr. Schwartz. You also have the next one, which is the civil penalty order on Bernard Mingo.
Yes, thank you, Mr. Chairman. This case involves Bernard Mingo, an insurance company examiner 2 for the Pennsylvania Department of Insurance, who failed to timely file a statement of financial interest for 2018. In this case, the parties have submitted a consent agreement proposing that the commission find that the respondent failed to file a statement of financial interest for the calendar year 2018 and impose a civil penalty in the amount of $150. The parties' consent agreement also provides for the respondent to make payment of the recommended civil penalty in installments. The respondent has agreed to file complete and accurate statements of financial interest for that calendar year 2018. Based on my review of the facts, I am the opinion that this consent agreement is consistent with commission precedent and is a proper disposition for the case. It's my opinion that the commission should impose the civil penalty agreed to by the parties pursuant to the consent agreement and order the respondent to make payment of the recommended civil penalty in installments as agreed to by the parties. Also, it's my opinion that the commission should order the respondent to file complete and accurate statements of financial interest for 2018 to the extent that he has not already done so. May I make the motion?
Yes, you can.
I move that the commission approve the consent agreement submitted by the respondent and the investigative division imposing the civil penalty in the amount of $150 against respondent Bernard Mingo for failing to timely file statement of financial interest for 2018. I move that the respondent shall be ordered to pay the recommended civil penalty in installments as agreed to by the parties per the consent agreement, and further, to the extent that he has not already done so, the respondent shall be ordered to file a complete and accurate statement of financial interest for calendar year 2018 within 30 days of the issuance of the commission's order.
Okay, motion made by Mr. Schwartz, the Mingo case,
Second.
second by Shelley Sims. Any questions? All those in favor signify by saying aye.
Aye.
Nay.
Aye.
The ayes have it. The next matter is the civil penalty order contested. Ms. Palma has and is on the Mark Jeanette.
Thank you, Mr. Chair. There is one contested civil penalty case that is now before this commission for decision. This case involves respondent Mark Jeanette, an administrative officer for the Pennsylvania Department of Community and Economic Development, who failed to timely file a statement of financial interest for calendar year 2017 with the Pennsylvania Department of Community and Economic Development. The respondent was served with a notice letter and a final notice letter, each of which informed him of the delinquency of his statement of financial interest for calendar year 2017 and provided him an opportunity to avoid the institution of civil penalty proceedings by filing the delinquent form. The respondent did not file the delinquent form, although he was given more than the usual grace period following notice in which to do so. The respondent filed a statement of financial interest with this commission after civil penalty proceedings were initiated against him. The statement of financial interest did not indicate the calendar year for which the form was filed. The respondent also filed an answer asserting, in pertinent part, that he did not receive the notice letter or the final notice letter. At the request of the respondent, a hearing was held in this matter. Although the respondent did not attend the hearing, he was represented by counsel at the hearing. The respondent's counsel presented no witnesses or other evidence in support of the respondent's assertion that he did not receive the notice letter or the final notice letter. The meeting materials that all the commissioners received included the parties' pleadings, the hearing record, and each party's brief and closing statement. I would note that in his brief and closing statement, the respondent asserts that there are mitigating circumstances in this case and that a civil penalty is not warranted because his business has been closed due to the COVID-19 pandemic, and these times are an economic hardship for everyone. It is my view that the evidence establishes that the respondent failed to comply with Section 1104A of the Ethics Act when he failed to timely file his statement of financial interest for calendar year 2017. There is no evidence of record to establish mitigating circumstances in this case. The respondent's assertion that he was not properly served with notice of the delinquency of his form is unsupported. There is nothing of record that would constitute a defense or excuse for the respondent's failure to comply with the Ethics Act. To the extent that the respondent contends that the levying of a civil penalty against him would constitute an economic hardship, his contention is unsupported. It is my opinion that the Commission should levy a maximum civil penalty of $250 against the respondent for the delinquent statement of financial interest for calendar year 2017. It is my opinion that the Commission should also order the respondent to file a complete and accurate statement of financial interest for calendar year 17. Mr. Chair, based upon my analysis and comments, I would like to make the following motion.
Yes, ma'am.
I move that this commission levy a maximum civil penalty in the amount of $250 against respondent Mark Jeanette for failing to timely file a statement of financial interest for calendar year 2017 with the Pennsylvania Department of Community and Economic Development. Further, respondent Jeanette shall be ordered to file a complete and accurate statement of financial interest for calendar year 2017 within 30 days of the issuance of the Commission's order. Mr. Chair, that is my motion.
Motion made by Melanie DePalma. Mr. Corrigan, you want to second it?
Yeah, absolutely.
You're just checking to see whether you're there.
We're still here.
Okay. All those in favor signify by saying aye.
Aye.
Nay, the ayes have it. The next item is on the subject of lobbying, and Melanie DePalma has that one too. It's by the Patriot Home Care Company.
Thank you, Mr. Chair. There is one administrative penalty case with a proposed consent agreement for our consideration. Respondent Patriot Home Care failed to timely file a quarterly expense report for the third quarter of 2019 in its capacity as a principal. Parties are in agreement that the respondent's transgression of the lobbying disclosure law was negligent. Respondent has now submitted its delinquent expense report to the Department of State. Based upon my review of the facts, I'm of the opinion that the consent agreement sets forth a proper disposition of this case, and I would like to make the following motion, Mr. Chairman.
Please do.
I move that this commission approve the consent agreement submitted by the parties and impose one administrative penalty in the amount of $7,170 as to Patriot Home Care for its delinquent expense report for the third quarter of 2019. To the extent that the respondent has not already done so, I move that Patriot Home Care be directed to pay its administrative penalty in the amount of $7,170 to be made payable to the Commonwealth of Pennsylvania and submitted to the commission within 30 days of the mailing date of the commission's order. Mr. Chair, that's my motion.
Motion made by Molly DePalma. The second, Roger, are you on?
I'm still here, I'll second it.
Okay, Roger, second. Just checking on you. All those in favor, signify by saying aye.
Aye.
Nay?
Aye.
The ayes have it. The next one is the administrative penalty order against the Westmoreland Economic Development Initiative in reference to non-filing, and Rob Caruso is going to talk on that.
Yes, the investigative division made a determination to withdraw the matter at this time, but it would be resubmitted potentially at a later commission meeting. The commission would not, the investigative division would not seek then to impose the additional penalties for the days going forward beyond today. But we want to give the company an opportunity to respond. We've had some trouble getting in touch with them.
Would questions be in order?
Sure.
That was my one question is, have we been able to contact these people? And what is their structure? Is it like a quasi-public corporation? And who sits on the board? We don't know.
There are a number of, there are educators, there are some public officials, some former public officials. They survive primarily on grant monies that are received, I think primarily through DCED. And
Yes.
the executive director is a township manager in Westmoreland County. And we've been trying to reach him and some other board members as late as Monday. And I've been able to do
And
so.
we assessed fines against them back in January, and they still haven't paid those. And now here we are in September, assessing an extraordinary amount of money against them. And it's, it's public money. And, I don't know what you're going to find out, but once this is all over, I wouldn't mind calling the Senator Kim Ward from Westmoreland County and say, what the hell's going on out there? I'm sure she would be furious. Probably the House members too.
I think that's a good suggestion. We need to contact Senator Ward and whoever other legislators they may have in that area, because the amount is, it's unbelievable. It's like
Well, we can't do it while it's pending.
Yeah, I agree. So I'd like to have a motion to pass over this matter until we communicate with them and see what the problem is and so on.
I also move to
Okay.
table the matter for now.
Okay, second on my motion.
Second.
All those in favor of the motion to hold this thing over? Signify by saying aye.
Aye.
The ayes have it. Very good. Thank you, Mark. The next matter is the election of officers for the chairman and vice chairman.
Mr. Chairman,
Sir. Yes.
fellow commissioners, Dr. Nick Collifel has served in this commission since December 2004. and was elected chairman in 2015. Shortly after my appointment in 2012, the operation of this commission changed. Nick was part of the movement of this commission, first as vice chair and continuing as chair, to open this commission to much more participation by every individual commissioner. Furthermore, I have never witnessed any type of partisanship in any of our operations. Fellow commissioners, I am pleased to place the name of the Honorable Nicholas A. Calafella in nomination for a new term as chairman of this commission.
Thank you, Mark.
I move the nominations to close. Roger.
Well, you made a motion to close the voting.
Close enough, yeah.
Okay. Any questions on this? All those in favor of Mr. Corrigan's motion signify by saying aye.
Aye.
Oh,
Nay? Thank you. Thank you very much. I appreciate very much this, but this will definitely be my last time. I can tell you that. So if you're interested down the road, because
Can we get a raise, Mr. Chairman?
the last year was something else, I'll tell you. But anyway, thank you all. I really appreciate it. You guys all have been great. And the participation with this commission has been wonderful. I'm somewhat overwhelmed by some of the intelligence of some of the people on this commission, and I'm really impressed. I mean, Harvard Law, Yale Law, person who headed the Senate for I don't know how many years, Roger Nick, who was Matt Ryan's chief assistant and did all the work for Matt Ryan, and that's why Matt, of course, was considered a very famous legislator. And, Melanie, you've been very good. You asked some very incisive questions, and I'm always impressed by that.
Thank you.
Well, thank you all very much. And the next thing we need to do is we need to elect a vice chair. Anyone want to make a motion for that?
yes, Mr. Chairman, if I could, it'd be my honor to nominate the Honorable Mark Corrigan as vice chairman for another term.
Yes, you may. Is there anything else you wanted to say about Mark?
Not in public.
Yeah, I was gonna say, don't remember when we were on the Hill Road.
Can I have a second?
Second.
Second.
Shelley Sims, seconds it, and Michael Schwartz as well. Any other nominations for that office? If none, can I have a vote? All those in favor of Mark Corrigan as the vice chairman, signify by saying aye.
Aye.
Nay? The ayes have it. Congratulations, Mark.
Thank you very much, fellow commissioners. This will be my last one too.
Thanks again, Mark. I'd like to just simply say Mark has been tremendous help to me, especially when we went to that legal thing about a year and a half ago. I could see why he went to the Senate as well as he did. And it's going to be great to work with you again, Mark. Thank you.
Thanks.
Okay. We now have the public comment period, and we have some people here that represent the Pennsylvania Women Rise, and you're welcome to stand up there and make a statement, whoever wants to speak. Please identify yourself, please.
Absolutely. Good morning.
Good morning.
How do I pronounce your last name? Calafella?
I've been called colored fella.
No.
Cauliflower, don't worry about it. It's cauliflower.
Calafella, thank you. Good morning. We have 3 people representing our organization. My name is Carmina Taylor. I'm one of the founding members of a group called PA Women Rise, and we're here to share some comments based on our experiences with your commission. I just want to publicly thank Mr. Caruso. I've been in communication with him at least since June, and he has been exceptionally hospitable and respectful and accommodating to me, and exceptionally patient. And I want to thank you, Mr. Caruso, for your professionalism and your tolerance of my multiple inquiries. So thank you. So we're here because we want to really express some things that happened to us as a result of filing a complaint process here. So we're coming with 3 different perspectives. I'm going to read you my statement, and then I'm joined with Abby Deerdorf and Marlena Green. She's a coalition partner, and she's another founding member. Okay, so forgive me that I took my mask off because I think I can be heard better without that. Is that okay? But I do want everyone to see that Black voters matter. Okay. This is a letter. We understand that this commission is established through the General Assembly. So I'm not making these comments to you. I'm writing to our General Assembly through your commission. So here we go. Dear leadership of the PA Commonwealth General Assembly, on June 1st, Montgomery County Commissioner Joe Gale posted a disparaging and erroneous statement about Black Lives Matter Philadelphia, its movement, and its purpose on Montgomery County letterhead on his personal and campaign Facebook page. This action not only sent shockwaves of anger across the county, but now 3 months later, it's a complete embarrassment to the constituents in Montgomery County that this public official has the responsibility to represent the best interests of over 800,000 residents in our county, but has been continually disrespectful of the 80,000 residents of Montgomery County that are Black with his blatant and libelous statements. Joe Gale's concerted effort to specifically target his social media platforms to gain notoriety outside the county and ultimately gain a higher number of followers is what led me to file a complaint with your commission on June 15th. As a lay person, I navigated through your website to find out how to file a complaint. When I found the criteria under section 1103A, a conflict of interest stating that, quote, no public official or public employee shall engage in conduct that constitutes a conflict of interest. I thought my argument that Commissioner Gale executed a conflict of interest as a public official, especially a financial conflict of interest, because I truly believe that he consciously posted that statement on social media to financially benefit himself and his campaign. Since June 1st, he has significantly increased his followership, which ultimately will gain financial backing from Facebook. When I received my first denial on June 22nd, it stated that in my complaint, quote, that it failed to state a cause of action under any relevant provisions of the Ethics Act. The jurisdiction of the State Ethics Commission extends only to financial conflicts of interest as defined in the Ethics Act. The conduct of Joe Gale, as outlined in your complaint, does not meet the conflict of interest criteria of the Pennsylvania State Ethics Act. As such, no investigation can be initiated, end quote. I believe that the commission should have investigated the facts and evidence that resulted in his singular benefit because of his social media posts. But when I received the second denial letter on June 30th, where it stated, quote, the investigative staff of the commission, including the investigative attorney, have further reviewed the information you submitted in support of the allegations of Joe Gale that violated the Public Official and Employees Act. The review concluded that any private pecuniary benefit received from Mr. Gale's use of Montgomery County letterhead for personal purposes would be de minimis and not rise to the level of a violation of the State Ethics Act, and as such is not actionable. So I wonder, how does a private pecuniary benefit not rise to the level of violation of the State Ethics Act? Because he gained social media followers, which will provide him funding that to me is a direct violation. Secondly, we feel that the Ethics Act needs to be reformed. It needs to be reformed to the level that citizens in Pennsylvania can truly hold our elected officials accountable for their unethical conduct and the impact that it causes on communities that have sworn an oath, that they've sworn an oath to serve. The Ethics Act was passed in 1978, and the narrow scope that's available to investigate a financial conflict of interest, for one, a failure to timely file a statement of financial interest, or two, a failure to file a quarterly statement of expenses, seems unrealistic for the more sophisticated, diversionary, unethical tactics that are presently used by public officials in Pennsylvania. The State Ethics Commission should expand to include an act covering blatantly racist and derogatory statements made by local officials. We must have a remedy under the state ethics laws. In conclusion, please understand Harrisburg leadership that Joe Gale's statement should not become a normalization of conduct by a public official. You have the power to change that. Please understand Harrisburg leadership that even though Joe Gale's statement was offensive to the Black community, it was more offensive to other racial groups outside the Black community. And even though the commission does not investigate conduct by public officials that is considered offensive or morally wrong, you still have the power to reform this Ethics Act. PA Women Rise and our coalition partners stand firm in the conviction that we will not rest until our state legislature and the commission responsible to oversee ethic violations by Pennsylvania public officials through the 1978 Ethics Act is amended for necessary reform. We constitute the establishment for this office through our tax dollars, and we want our tax dollars to truly work for the people, not the select few in power. So again, this is not an admonishment of your commission. I had the fortunate opportunity to watch all your previous public meetings in the last 2 years. And it was an educational thing for me, to be honest with you. Realizing what you do, how you investigate the fines, it's very fascinating. But I think that when you think about that this act was passed almost 40 years ago, and that we're in a different realm of how public officials function and state employees and everything else, I really felt that it was necessary to share our thoughts through our experiences. And again, it is no admonishment to the work that you ladies have done, because I've seen you carry a lot of cases too. I went all the way back to 2019, and Mr. Schwartz, he's a toughie. So, do you hear me, Mr. Schwartz? I've been watching you. So I just want you to know that I didn't take this lightly, but I did do my research to make sure that I had some kind of context in which I'm here. I do have one question. Can I ask a question?
Sure.
So the $250 fine and, or the penalties that are assessed, was that amount the same that was in 1978?
Yes, it is.
Yeah,
Yes.
I'm just saying.
Do you think we should increase it?
Well, the thing is that it's $250, and if you're 2 years, if they violated it 2 years ago, I just think that just shows that something has to change, because I don't want people to have to pay a lot. Maybe if you increase it, that might urge them to do it properly according to the law, but that's not relevant. That's, what did they say? That's not the rate of inflation, right, of 40 years. I must say, as a citizen, I do feel kind of bad, and I didn't realize, like, the people that Schwartz did today, they're like they're regular people. I didn't understand that regular people got fined for that are state employees. But then you have to look at it in our perspective, that we see other people in power with greater responsibility that aren't being held accountable, but the examiner of some agency in the state has to pay $250 and be mindful of that and still serve us. That's an imbalance, right? And this is just one law. I'm one law. I'm pretty versed on other things, and I think we have to address other Pennsylvania laws. But since I'm here, I just was wondering. And then, Mr. Colafella, where does that money go? Like, when you talked about the check or the money that they have to pay, the check to the Commonwealth, where does that money go? Where does the receipts of your revenue?
It goes into the state budget, into the Commonwealth of Pennsylvania's budget.
So it becomes a line item in the state budget as a revenue source?
General fund.
Just,
In the general fund.
All right. Well, it's been a fascinating.
Let me just respond.
Yes,
to
sir.
One thing. You're talking about regular employees, but these are generally people who have a responsibility to make major kinds of decisions
Okay.
financially.
Mm-hmm.
And so, in order to find out whether they've done it or not, a statement of financial interest is one way we can find out, for example, if they've made money through the Commonwealth. We find out they've made money through the Commonwealth, and it's not listed in that statement of financial interest. That's a problem.
So what do you mean by make money from the Commonwealth?
Well, let's say you're head of a department that makes major decisions about roads, for example.
Okay,
How much money should be given to certain construction companies,
okay,
as an example.
yes.
Okay, that person has a major responsibility. And we find out maybe through the statement of financial interest that she's made a little bit of money
On the side?
on the side.
Oh,
Is that a fairly good explanation for,
that's an excellent explanation.
that's the reason why a lot of them don't file. There are a lot of people who don't file because they don't want anybody to know, and we need to know. So that's why we find it.
So that's an excellent point. And so with us being lay people, we now finding that out and me knowing other things, I think everybody should be responsible for that, right? So here's my challenge to you in your last term. I think you, and I've been watching you too, and I've read behind you too. I think that you should take this last term and travel throughout the state where you do a tour, but educate the public about this office and the work and when you make these decisions here, why you make them. Do you know what I mean? Like educate, like just how you educated me or all of us here about the decisions you guys make. I think you should do that for everybody across the state. Like figure out a way to do that because it helps us understand the functionality more of this commission. And Abby and I were saying when we were driving up here, the fact that you focus on the financial aspects of this financial conflict stuff, maybe it should be the Financial Conflict Commission or something that stands out, even though the section has different parts that you can file a complaint. I mean, we take it, state ethics as a whole different level. Do you know what I mean? Lay people. And that becomes problematic when we're trying to figure out how we navigate the issues that we're confronted with. So I didn't come here disrespectfully, but I've learned a lot through the process leading up to today and certainly through your explanation as well. And I know I'm a pretty, focused person. And just trying to navigate ethics on one level when you see something happening in your local community and then you think you can file a complaint, but it really doesn't fall in line because the law is really narrow and then you're dealing with all these other aspects.
Let me just add one other thing.
Yes, sir.
I'll talk to the executive director about that. We probably should get a note to you to let you know who is covered by the act of providing the state of financial interest, and that is every school board member in Pennsylvania. When you take a township and they have commissioners and so on, okay, they are required to fill out a statement of financial interest. Every state legislator, every state senator on down has to, and so it's very prevalent. I mean,
Absolutely.
Okay.
But that's very important right there, because if you really look at it right now, local school boards and the governance of that is so important to people on the local level. And just understanding that they have to even submit that really important helps the layperson or the voter or the activist in the community help us educate people that are asking, what are they really doing? And if they have that enormous responsibility, that we need to take their job seriously and they need to take our desires seriously. So just the fact, and as much as I read on your website, I didn't know that the school board members have to do that. Do you guys see how beneficial that is for a regular person? And since you've been on since 2004, I say go out with your swan song with a huge avenue of education. So,
Thank you very much.
okay. I forgot the ladies. They have shorter
I have one
comments.
other
Yes, sir.
request. Would you kindly send a copy of your comments
Mhm.
to the executive director?
Absolutely.
Okay, so that we have it on record, okay?
And Abby and Marlena's too. We'll make sure it's, equality all the way.
Okay,
Thank you. So Abby's gonna speak now very briefly.
okay, yeah, we have a couple more things on the agenda.
We're still in the time frame of the longest meeting you've ever had, so we're good.
Hi, I'm Abby Deardorff. Nice to meet you all. So my activism has just started since this summer. And I've met Carmina and Marlena through the political climate that we're facing right now in our country and our state. And so it took a little bit of time, and I was invited to come to this meeting with PA Women Rise to review your annual report and some of the verbiage. And like Carmina said, when you think about a state ethics commission, to a layperson, to a mom of three who's a nurse, I think of moral ethics, or ethics of how you should conduct yourself when representing your constituents, not so much the finances of it. But I do see that people such as myself are waking up and kind of getting more involved in something like this and want to know more, and hold the people that are working for us as citizens accountable and kind of understand why processes are in place that they are. So something in the verbiage from your annual report in 2018 that hit home for me. It says, although there have been multiple changes to the Ethics Act and many additions to the duties and responsibilities of the Commission's mission has remained constant, that it's to strengthen the faith and confidence of the people of the Commonwealth of Pennsylvania in its government. This is done through a fair, impartial, and balanced application of the law. So what we have learned is that specifically that's the financial, ethics that you guys are in reference to. I'm curious to know if there is a commission or any avenues for more of the conduct-like things that we are concerned about, and primarily for me, because the law, as you want to call it, was applied this summer by myself to Commissioner Gale. Myself and 7 other constituents did bring a lawsuit against him for his blatant First Amendment rights violations. Mr. Gale can no longer filter criticism on his personal and campaign social media accounts under a settlement reached in our federal lawsuit. While I do feel vindicated in this success, I want this board to know that for the reasons we've presented to you here today, I do not, as a Pennsylvanian, to quote your mission, have faith or confidence in my government. Mr. Gale's been denounced by almost every municipality in Montgomery County. His co-commissioners have formally censured him, and he lost a lawsuit, yet he continues to spew hate, divisiveness, and seems to be singularly focused on furthering fear rather than unity and progress. How is there no accountability for these actions? This has to change. He settled our suit, so he was not found guilty, or, it was not a loss, it doesn't set precedent, but, he violated First Amendment rights of his constituents. If you want to financially focus it, he's making $90,000 a year to represent me, and I have not been able to see any tangible successes that he has made for our county, other than divide it and further. It's embarrassing that he exemplifies our state, and I just wish to know what can be done other than, he's up for re-election in 2023. Are there avenues that you guys know in your profession as far as holding these elected officials accountable?
Mr. Chair, may I speak to that?
Sure.
Okay. So the Ethics Act, which is what we deal with, is not the only thing that's out there. It's very specific to financial conflicts. Different governmental entities have their own codes of conduct if they wish. They're allowed to do that. They're not allowed to use that to undermine the Ethics Act, but they can supplement it. They can go beyond it. So, for example, in the General Assembly, they have rules of conduct. They have committees that looked into what they consider to be ethics violations as defined by those rules. Counties, boroughs, townships, school districts can all have their own codes of conduct if they wish to do that. Then, of course, you have the courts, which you talked about, which you turn to. I think the only other thing I would say is that the courts are there to balance those types of interests that you're talking about. You have First Amendment rights, those public officials have First Amendment rights, and that's why we have the courts to apply, the Constitution and to figure these things out. So it isn't just a simple one-stop shop where you can go and say, well, this is the body that's going to take care of this. There are lots of things that can come into play.
Okay. Because I do know, are you, either of you speaking about the resolution? We are trying to go.
No, but Danielle said that one of my colleagues said the courts take too long, so,
No comment.
Because we are trying to present, support a resolution for
Right.
misconduct, misbehavior. But, then it's a challenge to try to find, support to push that through, especially, this time of year with other focuses. So,
I didn't want to say that, but we do, Senate Resolution 334, trying to apply the law, but we have it still within the General Assembly.
I appreciate it. Thank you so much.
Okay, well, thank you.
Mr. Chairman, this is Mike, Commissioner Schwartz. May I just make a comment, please?
Absolutely.
So, I just wanna, was there one more speaker? Let me wait till after all the speakers, because I have some personal interest in kind of the issues they're raising, and I wanted to respond, but I didn't realize we had a third speaker. So let me defer my comments, please.
Good morning. I will keep this short because now that I'm understanding what's going on here, it was very informative. So it's like when you dig for information, you can't find it, but personally being here, you understand kind of what's going on. So I'm going to read what I wrote, but it kind of doesn't apply now that I understand what the Ethics Commission stands for, but hopefully he can give us some feedback, or you can give us some feedback on where we should go further.
Good morning. May I ask you just to please identify yourself?
Yes, ma'am. My name is Marlena Green. I am Marlena Green. Yes. Excuse my voice too, I lost it. So my name is Marlena Green. I am one of the founders of PA Women Rise. I stand before you as a mother, a sister, a cousin, and most importantly, I identify myself as being African American. As a native of Montgomery County, we are fighting for a system that does not represent the poorest residents. PA does not fund or govern public defense at the state level. These offices are governed at the county level. In Montgomery County, this has led to conflicts of interest that had adversely affected our poorest residents caught in the criminal justice system, residents we know who are disproportionately Black and brown. In February 2020, our county commissioner, Dr. Valor Cush, Kenneth Lawrence, and Joseph Gill fired the chief public defender, Dean Beard, and assistant chief Keisha Hudson. They were fired 2 days after submitting an amicus brief to a lawsuit brought by the ACLU and other advocacy organizations in front of the Pennsylvania Supreme Court about cash bail. The lawsuit alleges that Philadelphia judges are not adequate following the law as it pertains to the cash bail and wrongfully holding people pre-trial as punishment, not to ensure appearances and hearings as the law requires. The Montgomery County Office of the Public Defender was asked to submit an amicus brief detailing the cash bail system in Montgomery County. The brief detailed all ways in which bail is being applied in violation of the Constitution and the PA rules of criminal procedure. 2 days after submitting the brief detailing these legal bail practices, both Beard and Hudson were fired by the county commissioners. In doing so, the commissioners violated the Sunshine Act. The commissioners are now being sued 3 times, once by ACLU and individually by Beard and Hudson for the retaliatory act. The story was covered nationally in the Washington Post, New York Times, and widely criticized by national advocacy groups like the ACLU, NAACP, National Association of Public Defense, National Lawyers Guild, Philadelphia Defenders, and other local advocacy groups. Shortly after the firing, hundreds of county residents made public comments at the commissioners' meetings stating how unethical and outrageous the commissioners' conduct was in firings. The meeting went on for 3 hours. Still, the commissioners made no statement and took no action. We assert that the state ethics code must provide a remedy for this violation. It is unethical that the county commissioners share the same solicitor with the Office of Public Defenders. It is unethical that the county commissioners interfere with the public defender's constitutional mandate to provide zealous representation of their client. It is unethical that the county commissioners attempted to conceal ongoing constitutional cash bail violations. It is also unethical that they refused to answer the constituents who demanded answers, and to date have not provided any adequate explanation for their firings of taxpayers. Aside from civil remedies, there must be a state ethics standard that gives residents an avenue for holding their county officials accountable for this behavior. The commissioners have refused to meet with the advocacy group, PA Women Rise, and thousands of Montgomery County residents remain outraged at the incident and lack of accountability for the commissioners under state ethics law. I stand before you heartbroken and don't know where to get the right answers for the poorest people in our county. They are hurting, they are in jail. We cannot bail a lot of them out because of the unethical practices by Montgomery County commissioners. Thank you for having me, and I appreciate all the information that you guys gave us today. It was very enlightening. Thank you.
Thank you. Marlena. Well, in all three, you will provide a written copy to the executive director. So
We have-
we'll have it.
I have most
Oh,
of
I'm
them.
sorry, I didn't know you had it. Okay, thank you very much. I think we,
Well,
learned a lot
Can we hear
from
from
you,
Mr.
too.
Schwartz?
Mr. Schwartz.
Yes, Mr. Chairman, may I just make a remark? Because
Absolutely. Go ahead.
I think it is incredibly impressive that Ms. Taylor, Ms. Deerdorf, and Ms. Green traveled to Harrisburg in the midst of this pandemic to state these concerns. And I commend them for coming here. And as they recognize, this commission's authority is limited to a law, the Pennsylvania State Ethics Act, that was passed by the General Assembly. And I know it's frustrating sometimes when you look at a law that's titled ethics, but it can't address all of the concerns that you have raised and others have raised regarding what you think and what, the common definition of the word ethics may be. But I just want to share two experiences and offer a suggestion to anyone, to the three folks who testified or appeared today, and to anyone who has similar concerns. As a former federal prosecutor, there were many cases where I thought that there was corruption, but it didn't fall under federal laws that criminalize certain acts. I've had the privilege of serving on a mayor's task force on ethics campaign finance reform. And as Ms. Hitty, our counsel, had explained just a few minutes before, oftentimes there are areas of relief to address these concerns that's not always state or federal law. And the Philadelphia Mayor's Task Force that concluded in 2009 made recommendations that were passed as city ordinances, among other things requiring disclosure of lobbying on a local level in addition to what was on the state level. So I just wanted to offer my thanks for speaking out and commend your efforts and recommend, as you did today, that you continue to raise your ideas about potential legislation, about potential reform to all entities that may be able to consider it. And you will have a video recording of your testimony today, and I encourage you to share that with those who make the laws, whether on the local level, on the state level, or on the federal level, so that individuals like the commissioners here who are charged with administering and enforcing a state statute have more tools. Your suggestion about the fines for certain violations, while I think the concern about how it affects certain lower level people are valid, you also point out that those fines have not moved for 40 years, and whether or not it deters others to comply with the law is a legitimate question to be raised. So I thank you, and Mr. Chairman, I thank you for the time to add my comments.
Thank you. Would any other commissioner want to say anything?
I'd like to just echo Commissioner Schwartz's comments and to encourage you to continue to speak and to use the avenues that are currently available to enact or hopefully get legislation enacted that is more aligned with what you believe as citizens and as voters should be appropriate and should be done, so that, as he said, those who are interpreting and implementing have more tools and are less limited. Thank you for recognizing our limitations, but thank you for also being here, especially under the circumstances.
It was important.
And for voicing your concerns, so.
Thank you again.
Thank you.
And we really appreciate you coming down here and sharing your views with us. I think we've learned a little bit from you too.
Well, I want to meet Mr. Schwartz before the end of the year.
Thank you very much. I wish I would have been as brave as you traveling to Harrisburg today. But my information is publicly available, and I would welcome any type of contact.
Thank you, Mr.
Thank
Schwartz.
you.
Thank you.
Thank you very much. Have a safe trip.
Thank you so much. Have a
Okay.
good one.
Oh, Michael, you have a reputation.
Okay, we're now going to move to the executive meeting.
We need a motion to adjourn, Mr. Chair.
What's that?
A motion to adjourn, is there a motion to adjourn?
Motion to adjourn. Motion by Nolan.
I'll second.
Second by Shelley. All those in favor signify by saying aye.
Aye.
Thank you.
We need to make sure is this off?
Not yet.
Okay, we need a little time. It's
Okay.
being live streamed.
Yeah, turn off the